Hey out there, legal warriors. In this video, I'm going to cover the 3 types of cases that are criminal cases that your attorney may be able to get dismissed in Washington State. There's 3 big ones that have a more well-recognized path to dismissal, and if you have one of these 3, I want to make sure you're on the right path. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, as always, just jumping right into it. What are the big 3? The big 3 cases that have sort of a more well-defined path to an absolute dismissal would be a case of domestic violence, assault in the 4th degree, that's a gross misdemeanor. Theft in the 3rd degree, that's also a gross misdemeanor. And finally, a hit and run charge, which would either be attended, which is a gross misdemeanor, or unattended, which is a simple misdemeanor. I think those are the 3 most common types of non-felony criminal charges in Washington State that can have a path towards dismissal. Now, I may not apply them and go over each of those in that exact order, but there's different ways that each one of those cases can end up where hopefully the defendant wants it with no convictions and a dismissal. So let's start with case number 1, a domestic violence assault in the 4th degree. What do I mean by that? Well, assault in the 4th degree is a very serious charge in Washington State, but it's the lowest form of assault. So assault 3, assault 2, and assault 1 are all felonies, and those are committed by different ways. Either the type of assault, maybe a strangulation, or if there's an injury, it might be a higher level, or a weapon is a higher level. So think about assault 4 as any unwanted touching that does not involve a weapon, does not involve stitches, does not involve any broken bones. That's the most common case we're going to see. And so assault in the 4th degree is that gross misdemeanor crime, and the most common way that someone can try to get one of those cases dismissed is not at a jury trial. Remember, we want to try to avoid jury trials if we can. It's with negotiation with the prosecuting attorney. More often than not, the alleged victim in one of those charges is not going to support a full prosecution of the defendant for various reasons, because of the family member, because of complications, things like that. And so therefore, there are more paths to end up with a dismissal in that type of charge than others. The most important thing we want to work on in that type of case is doing some type of treatment. Even a totally innocent defendant needs to typically do some type of affirmative class or classes to make it more possible for the prosecutor to listen to defenses and give the defendant a path towards dismissal. The most common classes in a domestic violence case would be domestic violence, moral recognition therapy, DVMRT. It's a 6-month class. It's pretty inexpensive. It's objective. And talk to your attorney if that might be useful in your DV case if you're charged with that type of crime. It varies for each court. Seattle Municipal, they have their own type of thing they'd prefer to do. Certain other places want something different, but many places are satisfied with DVMRT. Now, the method towards a dismissal typically is something called an SOC, a stipulated order of continuance. The stipulated order of continuance is a contract between the government and the defendant that requires certain things of the defendant, like those classes and staying out of trouble, and maybe some other stuff too, sometimes pay some cost to monitor the agreement, and then requires certain things out of the government. Hey, dismiss the case if the defendant lives up to the contract. Now, usually there's a period of time that the prosecutor is going to ask the defendant to stay out of trouble for. That's the length of the SOC. 18 months is very common. 24 months is not unusual. 12 months is on the short side. So think probably around 18 months. In many places it could be less, it could be longer. So what do you give up in an SOC? You give up your right to a trial. And so if you blow the SOC by getting a new violation or don't do what you're supposed to do, you'll likely get convicted because there'll be a stipulated trial on the police report. So that usually doesn't happen if you enter into an SOC. You control whether or not you successfully complete it, and our clients typically always successfully complete an SOC. If the case is really weak for the government, sometimes you can get a straight dismissal without having to go through the SOC process, but it's very unusual. If that SOC is available, the government's going to really rely on that to give them some insurance to make sure they're not making a mistake by having your case dismissed. So that's a well-worn path towards dismissal in many DV cases. If we move on to the second type of case that I mentioned, that's theft in the third degree. Theft in the third degree, think about that as shoplifting. It's any amount of theft that's $750 or less. That's what it says by statute. In reality, many places it's like $1,000 or less. Many places won't prosecute something that's not much over $750 as a felony. But the most common way we get a theft in the third degree case dismissed is through something called compromise of misdemeanor. Compromise of misdemeanor is a law in Washington State, RCW 10.22.010, that says that if a victim of a crime has a civil cause of action for the crime, and they state that they've been civilly satisfied for their damages, upon motion of the defense, the court can discontinue the case against the defense. That's literally what it says. So it sort of means the court can dismiss the case if us defense people can get the alleged victim in the theft case to sign a release saying they've been civilly satisfied for their money damages based upon the bad act of the person who did the shoplifting. And so what does that all mean? Well, if someone gets stopped for shoplifting, most stores are going to send a demand for money outside of the criminal process. It's what we call the shopkeeper statute. There's a law that says that if a store has a theft from it, the store can basically apply a civil penalty for liquidated damages for their enforcement costs to the suspect who supposedly took something from the store. And that amount is limited to the amount of the items taken, the value, plus a certain amount of money. I'd have to look it up, but it's probably maximum $600-700 on top of that, something like that. And each store has a different way of doing it. And so some stores, when someone gets stopped for shoplifting, want you to pay something right then, but most of them don't. Most of them have employed a law firm, some out-of-state law firm from Florida or from New York, and they're going to send a demand for money in the mail. And I want you to talk to your attorney because every place is different. Like Nordstrom, they're going to do it in-house. That's going to come from someone at Nordstrom. Macy's is going to do it over here, and Target's going to do it over there. And some places won't do it at all. Like Costco, they don't even do demands. And so it's the one time we do want to get something in the mail where someone wants money from us, because now your attorney may be able to have you pay the attorney the money to pay them. Then we send them the money requesting them that they sign a release that we can then use to try to use this law, compromise of misdemeanor, to get your case dismissed. And so that's one of the most common ways we can get a theft charge dismissed in Washington State. If we can't get that, then we have to look at who your prosecutor is and see, can we negotiate? Can we negotiate for that SOC that we were talking about before? Can we negotiate for a straight dismissal? Each city is going to have their own way, and each county is going to have their own way of doing things. It's going to be a culture. It's what I call a culture for how they handle certain charges. And if your attorney has at least a high enough volume of caseload to have information, they're going to have a very good idea of what to expect in each jurisdiction. We're not going to know for sure, but we're going to have a very good idea from experience. So moving on to the third type of charge where we can usually see an identifiable path to dismissal, that's a hit-and-run charge. A hit-and-run charge, the path to dismissal is pretty similar to the theft charge, compromise of misdemeanor. It's another one of these cases where the victim of the crime usually has some damaged property, and maybe your insurance company is going to pay for the damage. That's why if you watch our hit-and-run videos, we always say, yes, we generally prefer that someone reports the damage to their insurance company so the insurance company can pay that, so we have a better chance to get that release from the victim. Now, it's harder to get a release from a person than it is from a store because sometimes they're mad, right? They're mad that you ran into their car or whatever happened and now you got charged with a crime. They're mad about it. So a good strategy for defense is we might not ask for that release right away while everyone's still mad. We might delay some period of time so there's less anger from the other side, so they're more likely to sign the paperwork. And it's even better if there's some out-of-pocket expenses that haven't been covered, because then we can offer to pay those out-of-pocket expenses in return for signing the release that we're going to need to ask the court to dismiss the case under that compromise of a misdemeanor law. So more often than not, we can get some type of a cooperation if we do it right from the person on the other end, and then use that to try to get the case dismissed. And of course, on a hit-and-run attended case, it's very important we don't get convicted of that because that carries a 1-year suspension. You're not even eligible for an interlock license or something. It's basically a worse suspension than most DUI cases, which I think is crazy, but that's the way the law reads today. Again, if we can't get the compromise, then hopefully we're using your lack of a record to negotiate some other way of doing things. If they won't sign the release, maybe we can still show the prosecutor that you've paid the damages, and maybe we shouldn't be punished because we can't get this release signed. Maybe you should still have a good result because the damages have been paid. Maybe we need you to do an aggressive driving class, things like that. But these are the things you're going to want to talk to your attorney about to see if that might be a useful way for a path towards dismissal on your case. So what do we normally think about as the public? We think, hey, the only way to get a dismissal is go to trial or say I didn't do it or stuff like that. But most of the time, let's face it, if we got charged with a crime, we'd probably have some exposure. We'd probably have some liability. We want to try to still use these paths towards dismissal to get somebody the best possible result. And whether you're using our firm or another firm, at least I want you to be educated to have some idea about the ways that we can typically get the system to let us go without having to risk what a jury has to say about what happened. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you got a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we'll be there for you. Thank you.